50525 in the motion for sibling visitation. We now have Mr. Warner who's joined us. Let's reiterate our appearances, please.
Alexis Spencer, attorney for Amber Million.
Kimberly Kuhn, attorney for Amber Million.
Suzanne Wilhelm, attorney for Angelina Warner.
This is the circuit court case. I'm not sure you've been.
Oh, no, I'm not. Okay. Sorry.
You got both set though for this morning, and we appreciate you being here. We do have Ms. Million again. Yes,
Amber Million.
Thank you.
Sean Head, appearing on behalf of Dale Warner.
Rebecca Haynes, on behalf of Dale Warner.
Thank you. All right, you may proceed.
Thank you. This matter is before the court on plaintiff's motion for temporary visitation orders with her minor sibling, Angelina Warner. Your Honor, I'd like to request that we refer to Angelina as AW moving forward.
Agreed. Any objections?
None.
No objection.
Thank you. The evidence presented today will show that at the time plaintiff filed her complaint for third-party visitation on April 7th, 2023, plaintiff had not had any in-person nor phone contact with her minor maternal half-sibling, AW, since July of 2021, due to the defendant and the minor child's father, Dale Warner, not allowing the plaintiff nor her siblings to have such contact with their minor sister. AW, after the defendant's wife and plaintiff's mother, Dee Warner, disappeared. The main issue of a sibling having standing to bring an action for visitation in the circuit court is a case of first impression in the state of Michigan, as there is no controlling case law regarding the issue of a sibling having standing to bring an action for visitation with their sibling, nor are there any statutes that discuss this issue. Although the state of Michigan does not have any case law nor statutes regarding the issue of a sibling having standing to bring an action for visitation with their minor sibling, 20 other states do. Those states include Washington, Oregon, Nevada, California, Alaska, Colorado, North Dakota, Oklahoma, Arkansas, Louisiana, Illinois, Georgia, New York, Rhode Island, Connecticut, New Jersey, Delaware, West Virginia, Virginia, and South Carolina. In Michigan, MCL 722.27b is the most analogous statute, which discusses grandparent visitation and when a grandparent has standing to bring an action for grandparent visitation. However, here, we do not have an issue of grandparent visitation. We have a case of a biological sibling who is attempting to establish visitation with her minor sibling after their mother went missing and or was murdered, per the current pending murder charges against the defendant. There is no case law nor statutory guidance in Michigan that could be found after extensive research into the issue of third-party sibling visitation, nor is there any case law or statutory guidance that prohibits third-party sibling visitation. Therefore, plaintiff is making a good faith attempt to obtain an order for third-party sibling visitation with her minor sibling and expand the law in Michigan regarding standing for sibling visitation. Under Michigan's Children's Foster Care Manual, Michigan requires that siblings in foster care must have regular contact, both via in-contact visits after the first 30 days of placement, as well as virtual contact to occur as frequently as possible and desired by the siblings. This supports that Michigan has a strong public policy towards sibling bonds and sibling visitation occurring. Under Troxel v. Granville, 530 U.S. 37, 2000, the United States Supreme Court held that an order for third-party visitation is not unconstitutional so long as the fit parent's decision regarding the upbringing of their child is given special weight in the decision to grant third-party visitation. In Soltes v. LaRoche, 2021, Lexus 2327 at 11, a fit parent was defined as a parent who adequately cares for his or her children. In the Soltes case, the Michigan Court of Appeals ultimately held that although the defendant father of the minor child in that case was providing for his daughter's material needs on a daily basis, he was an unfit parent when it came to providing for his daughter's mental and emotional needs of allowing her to have contact with family members. And that can be found at pages 7 through 8. It is important to note that the Soltes case was in regard to grandparent visitation and not sibling visitation. Regardless, though, the court in Soltes upheld the trial court's order of grandparent visitation and stated that because the minor child had a very close relationship with her grandparents, the loss of contact between the minor child and her grandparents created a substantial likelihood that the minor child would suffer mental or emotional harm. At issue before the court today Plaintiff submits that the Soltis case should be considered when looking at the defendant's fitness when making the decision regarding granting sibling visitation in this matter. Additionally, circuit courts have ancillary jurisdiction over probate court actions involving minor guardianships and visitation matters under MCL 600.1021, Section 2A. And therefore, plaintiff is requesting that the circuit court use their ancillary jurisdiction over the probate court matter to enter a similar sibling visitation order in the circuit court matter. Sibling bonds are important in general, but in circumstances such as the one before the court today, where a child's mother is missing and or deceased, and the child's father is incarcerated, a sibling bond is not only important, but necessary, as plaintiff is the only other person who truly understands the grief and trauma AW is experiencing. Plaintiff is respectfully requesting that this honorable court enter an order for sibling visitation between the minor child and plaintiff and the other maternal siblings, similar to the temporary visitation orders entered in the probate court action.
Thank you. All right. Who will be presenting? Ms. Spencer? Go ahead.
Your Honor, Rebecca Haynes appearing on behalf of the defendant in this matter.
Sorry. Thank you.
Your Honor, there is no basis under the state of Michigan established case law to support plaintiff's position that a half sibling in this matter should be granted visitation of a minor over the objections of a fit parent. Mr. Warner has a fundamental right to make parenting decisions regarding Angelina without interference from the state that has been well established by Michigan case law, as well as the Supreme Court of the United States. In this particular matter, Mr. Warner's parental rights have never been terminated nor suspended. He does continue to have that fundamental right to this date. With respect to whether or not there is any case law in Michigan specifically regarding sibling visitation, that's not true. In 2012, there was an undecided case before the Michigan Court of Appeals in Reed-McDonald, in which the court there overturned an order from the Kent County Family Division, which had required visitation between two siblings over the objection of the mother. Specifically, that court noted that even though the trial court had power over the children in that matter, because there was a family law dispute, that the trial court had extended its power improperly, and in doing so had interfered with the respondent's fundamental right to parent the child by entering an order that compelled the siblings to have visitation over the objection of the mother. Furthermore, even if we were to follow the outline of the grandparenting visitation statute, which is MCL 722.27b, there are several guidelines under that statute that are simply not met in this case. First of all, again, we have siblings, not grandparents. Second of all, under that specific statute, it does state that in order to give deference to the decisions of a fit parent, it's presumed by the proceeding under the subsection that a fit parent's decision to deny grandparenting time does not create a substantial risk of harm to the child's mental, physical, or emotional health. In order to rebut this presumption created, the grandparent, or in this case, a sibling, if we are to actually apply the statute, must provide by a preponderance of the evidence that the parent's decision to deny visitation time would create a substantial risk of harm to the child's mental, physical, and emotional health. The motion should be dismissed if by a preponderance of the evidence this presumption is not overcome. And in this matter, there has been no evidence that Mr. Warner is an unfit parent, and there has been no evidence that that this presumption has been overcome here. Furthermore, I'd like to indicate that in this whole case that plaintiff has referenced is easily distinguishable from the facts and circumstances in this matter, specifically with AW. In that case cited, the parental grandparents of a minor child had sought grandparenting time after their son died of cancer. Several witnesses were presented in that case indicating that the grandparents had a substantial connection with the child. Furthermore, there was other witnesses presented, including family members and a licensed expert psychologist, to indicate that the defendant mother in that case was adamant that her minor child was not suffering from mentally suffering mentally or emotionally following the death of her father, which again, several witnesses in that case indicated was not true. Therefore, in that case, the court determined that the defendant mother was unfit with respect to the mental needs of her daughter. If this court is to move forward with allowing visitation, this court, following that case, again, with respect to a grandparent but not a sibling, would need to indicate that Mr. Warner is no longer a fit parent with respect to the care and needs of his daughter. Lastly, Your Honor, even if we were to follow the grandparenting statute, and even if it were applicable in this matter, after all of that, the last thing the court would need to determine is whether or not it is in the best interest of the minor child AW. In this particular case, as we've heard earlier today, Mr. Warner is currently incarcerated on charges for murder. He is innocent until proven guilty. There's several social media posts and statements being made by the plaintiff as well as family members that he is guilty, and that several other things that just have not been proven to be true at this point. It would be mentally devastating to the minor child to be subjected to those statements over and over again in this matter. Therefore, we respectfully request that this court enter an order denying plaintiff's motion as well as any other relief, including but not limited to the dismissal of this suit.
Thank you. Thank you, ladies. I have reviewed the pleadings as well as the motion for temporary visitation orders. Obviously, we're here on this matter as well as matters this morning in the what I would describe as nearly a companion case, 23-52933 GM, wherein there is a visitation order currently entered that does reflect the temporary suspension of Dale Warner's parental rights as a result of the temporary appointment of the guardian. So we're not operating in a vacuum here, and I think that needs to be noted for the record. But second, so what that means, as far as I'm concerned, is that there's no need for a temporary visitation order in this case on an emergent basis. Secondarily, I think you both raised interesting issues. Number one, as to whether or not the suspension of his parental rights on a temporary basis or otherwise would cause the court to consider whether or not he is a fit parent for purposes of determining whether or not to look at the issue of visitation with a sibling. So I would like to have some briefs on this issue, on your positions as to argument on whether or not he is fit or unfit for purposes of invading his parental authority and ordering sibling visitation. Secondarily, I'd like to see the cases that you both referred to. I have your pleadings, but I don't have any briefs in support on any of the motions or objections that I can see in the file. So, for example, I heard about the Soltis case, I think you said. I heard another case mentioned, N. Ray Donald. I have not had those presented to me to review. I also heard a reference to a litany of other states that have entertained this particular issue. So I'd like briefs on whatever you'd like me to know as far as supporting your motions, objections, petitions, but also specifically on those two issues. And I would invite you back, if you're available, January 19th at 9:30 in the morning. And if you're not available, I can look at alternate dates and times.
I believe that works for the clinic.
That would work for us as well, Your Honor.
All right, very well. Then Ms. Spencer, I'll ask you to draft the order just indicating that the motion for temporary visitation orders is denied, and asking both counsel to brief their positions for purposes of a hearing on your underlying complaint for Friday the 19th of January at 9:30 in the morning.
Your Honor, just for clarification, when would the briefs be due, and is there a page limit or extension of the standard page limit?
The court rules would apply for purposes of your briefs, and please follow those. Don't send me a motion asking me to extend it. There's no need to do that. If you need to attach the cases, that's one thing. But please keep your briefs within the limits prescribed by the court rules And for purposes of reviewing those, if I give you January 12th, that's 7 days ahead of time. Or do you want the 5th? I understand that this is going over the holidays, so I don't love the idea of giving you homework over Christmas, but I do understand that, well, for the court rules, for purposes of the court rules, it'd be a brief from you and a brief from you. Anything else, a brief to a brief is not gonna be authorized unless there's something in the court rules that allows you to do that, so.
January 12th would work for us.
It's fine, Professor.
Very good. Any other questions?
Not for much, sir.
No, thank you, Your Honor.
All right, thank you. And that's all in the matter for this file for this morning.